So under Section 303C of the Clean Water Act, states are obligated to develop these water quality standards, and so they're intended to work to achieve those beneficial uses, which include, propagation of fish, shellfish, and wildlife, those agricultural and and industrial supplies, and navigation, and that's set out in 101A of the Clean Water Act. Two key aspects of this program are that, for the purposes of the Clean Water Act, those standards are not effective until EPA reviews and approves them. And once those standards have been reviewed and approved and are in place and are being used by the states and tribes do need to take another look at those standards to make sure that they don't need to be refined further or changed. They need to do that every 3 years, and that's called a triennial review. So there's 3 sort of required components of the water quality standards. The first is the designated uses, the water quality criteria. The second is the water quality criteria, and the third is the anti-DEG policy. And so those are the 3 required elements of water quality standards. And then the last is optional, so it's at the state's discretion whether or not these are included. And those are general policies, and they can include things like mixing zones or variances. So firstly, let's just flip back to, actually maybe it'd be better if I advance this. Designated uses, states put these in place by considering, the use and value of that water body for achieving those 101A uses. So once again, those are, public water supply, the protection of fish, shellfish, and wildlife, and recreational, and ag, and industrial, and navigational purposes. And so in setting these uses, the state is supposed to, kind of sit down and look at the water body and figure out what is this water body suitable for. And that's based on considering, so the physical, chemical, and biological characteristics of that water body, and any sort of other characteristics like, the geographic location, and other qualities and economic considerations. And I guess one thing to note here is that if for some reason the designated use that's been identified is not one of those 101A uses, the state would then have to undertake a use attainability analysis, which is an entire process, and that's laid out in the water quality standards regs in Section 131. So it's 40 CFR 131. So you can look at that if you want more detail, and it's also laid out on our website as well. So the second required element of our standards are the criteria, and criteria are basically sort of the level of pollutant that that water body can handle and still achieve that designated use. So states and tribes will adopt these, and they are intended to be stringent enough so those designated uses can still be met. And so there are basically 3 options for states and tribes in adopting criteria. They can adopt EPA-developed criteria, which are developed under 304A of the Clean Water Act. So under that section, EPA develops recommended criteria, and states can then just adopt those as they see fit. The state has the option of modifying those criteria, sort of based on any site-specific considerations or data that they have available. And then lastly, they can adopt their own criteria based on, state available data or studies that they've conducted for that specific parameter that they're intending to address. Any questions?
Yeah, just 2 quick questions about this specifically. what happens if the water quality criteria changes over time based on new scientific knowledge? Like a state has set an acceptable, for example, mercury level that is then found to be too high, but perhaps if the water authorities has met that level, and what happens in a situation where there's a ratcheting down of the criteria over time? How does states assess that? I can't remember the other question.
So where the water quality has actually improved then over time?
No, where the permissible level is scientifically determined to be lower than the previous acceptable level.
Well then, I guess it depends on what EPA has done. I mean, like mercury is a great example that things have changed with mercury. They've changed over time. So EPA did change its 3 or 4A criteria, and that was updated. I think that was a few years ago. I can't remember exactly what year that was. So we came out with, the new criteria, and there was an implementation guidance, and so states were supposed to change to sort of square with that. So either they would adopt those 3 or 4A criteria, or they would come up with their own approach, based on their own state available data.
But what happens if they've already exceeded the new limit? Like they're in attainment with the old limit, but they're not in attainment with the new limit? Is there like a remediation plan required?
There isn't a remediation plan required, but with mercury, for example, in the implementation guidance, there was an approach sort of described in there that provided states with the ability to then, because let's see, they went from, they changed the approach. I don't want to get into too much detail, but they changed the approach for what people thought would be the best way to address mercury. So instead of looking at the water column, they're focusing now on fish tissue. And so we laid out sort of a pathway to addressing that. I believe that a similar effort is going on with selenium, where they're sort of shifting. The science has changed. There's a better understanding of how it works in the environment, and so once again, EPA is working to sort of lay out the approach that states should take for that. So things do change, and then I think that the states are obligated then to sort of change with that, evolving science.
I was just going to ask, does EPA have a hammer there if the states don't do that, or do citizens have a hammer if the state is choosing not to act in the face of that sort of evidence or request from EPA?
Yeah, so that's a great question. So that triennial review process is supposed to help with this because it's supposed to be, the state and EPA sort of taking another look at the standards and whether or not they are effective or they make sense anymore. And so they're supposed to change in response to that. So that is one kind of hammer there. In terms of the citizens, I would have to think about that a little bit more. Yeah, about how you would do that.
Sorry, can I interrupt for a moment and make an announcement to our webinar folks? I know that you've been experiencing a lot of technical problems all day today. We're really sorry about that. We were doing the best we could to get this to work. Right now, you're probably seeing a blank or a screen frozen on slide like number 2, and you might be hearing the audio through your computer. If you are having audio problems, you can try to dial in information on a telephone line, and my suggestion would be to pull up the PowerPoints off the website. You can find this event page and follow along with PowerPoints. Then I would just ask our presenters to once in a while give them some clues as to what slide you're on, what the title is, or whatever as we go. That'd be useful. Again, really sorry for all this, and thanks for hanging in there with us.
Yeah, just to follow up on that, I think it strikes me, am I right, that EPA, there's a section where EPA can make the administrator or the administrator can delegate to the head of a region to make a determination that a water quality standard is inadequate?
Yeah.
And then that would force either the states to act or EPA could then set a standard if the state chose not to.
Right, we do have the ability to over promulgate essentially for a state, but that doesn't happen that often.
Yeah, very rare.
Right. And I mean, I guess an example of that would be in Florida, in the Everglades. We did make a determination there, but I think we backed off.
Yeah, it's a good question. It's a tricky issue.
It is. In
particular.
Little thorny. Yeah. so there are basically two forms of criteria that states and tribes can adopt. They're numeric or narrative criteria. Numeric, as the name suggests, is just setting a number for that pollutant level that is intended to protect the designated use there in the whatever water body that you're concerned about protecting. The narrative criteria, on the other hand, are a little bit trickier. They are qualitative statements, and there's an example here from Massachusetts, the Massachusetts Water Quality Standards. And this is kind of a typical kind of narrative, pretty, broad, and has the language sort of free from, woven throughout it there. And so implementing these criteria are a little bit trickier because, as you can imagine, you're not dealing with a specific number as your target. So if you're writing a permit to that, for example, you would have to figure out, what does this mean? A lot of states have come up with sort of translators, sort of taking this language and translating it into specific pollutants that they're concerned about and specific numbers associated with those pollutants. But these are very tricky to implement. And so then turning now to 402, and I know we didn't cover anti-DEG, but that's kind of its own whole beast there. And so, and that was, and just to once again, but that is another required part of the water quality standards. We're just not getting into it today. The one thing I want to note about anti-DEG is that, in addition to adopting just an anti-DEG policy, states are supposed to accompany that with procedures for implementing it. So they're supposed to explain how they're going to implement their anti-DEG policy within their state. So turning to 402, 402 is that National Pollutant Discharge Elimination System program that we had touched upon earlier, which prohibits the discharge of pollutants from point sources into waters of the U.S. without a permit. And so then permits are written using that information in your water quality standards. So you would use the criteria that's intended to protect that designated use. You'd also look at the anti-DEG policy, and that would govern, what's applicable to that receiving water that your discharger is discharging into. And then lastly, you would look at whether or not there are any general policies in your state, and those include mixing zones or low flows or variances. Let's see. And so the last thing I wanted to note here is that states and tribes, as I mentioned before, can be approved to run their own NPDES programs, and most states do in fact have those programs. No tribes have come in for approval to run their own programs, but they do have that ability to do so if they are interested in doing it. And EPA's role in those approved states, we play an oversight role there, and that's just to ensure that the states are implementing their programs consistent with the Clean Water Act. So here's just kind of a map of all the mainland states here, and we list out the U.S. territories. And so the only territory that sort of is partially authorized is the Virgin Islands. So in the case of those other territories, EPA is responsible for running those NPDES programs. And the other thing to note here is that Washington D.C. is not authorized to run its program, nor is Idaho, New Mexico, New Hampshire, Massachusetts, or New Mexico.
Not to put you on the spot, but did DC have authorization and lost it, or they just never sought it? Do you know?
They've never sought it.
Gotcha. Okay.
Yeah. And I think, Idaho is in the process of potentially coming in for their own program. They have sort of a negotiated rulemaking process in place where they are, they've developed some draft regulations, and they have this sort of open public process which involves stakeholder participation. So they potentially would be coming in with their application.
I had a question about how do they enforce the water criteria that they set out? Do they enforce that through this permitting program? If they have to drop every single point source
the body of water would be able to reach the criteria?
Okay, that's a great question. So the criteria are implemented through permits, and so in that respect, you would enforce sort of the whether or not the permittee is complying with their permit. In terms of, do you just mean, generally speaking? Well, I guess the other place where there's sort of check on criteria is just the fact that in order for the criteria to be, put in place in the first instance, it needs to be reviewed and approved by EPA. And so EPA would consider whether or not that criteria is, scientifically defensible. And that would entail looking at, the underlying studies that have been, and other information that the state has provided supporting putting that criteria in place. And certainly, citizens do have the ability to make sure that the state is, complying or complying with that criteria, implementing it correctly, because there are some checks available with that, and I think we're going to touch on that a little bit later in the
Chesapeake Bay in particular.
Yep.
It's hard though.
Yep. So, as I mentioned, the 402 program is focused on the discharge of pollutants by point sources into waters of the U.S. So one of the questions that come up is, what is a pollutant? This slide is just the Clean Water Act definition of pollutant. This is not in the entirety. It's very exciting as it stands right there. Just one key thing I wanted to highlight on this is just quickly that, it's a very broad definition, but it specifically does not include two key things, sort of the sewage from vessels or injected waste. Those are covered by other Clean Water Act programs. So sewage from vessels is under 312 of the Clean Water Act, and injected waste is generally covered by, the Safe Drinking Water Act. So then, what comes up in terms of NPDES? What is a point source? And once again, this is the Clean Water Act definition of point source, and it includes some things that you would typically, that would typically come to mind as a point source, like pipes and ditches and channels. But it also includes things like, vessels or other, floating crafts, concentrated animal feeding operations. So some things that you would not typically consider as like, that sort of direct conduit into a surface water, for example. So once again, there are a couple of exclusions. It doesn't include return flows from irrigated ag or agricultural stormwater runoff. And these exclusions were included by Congress in the Clean Water Act. That's what we're kind of working with. And just to transition, so since there are point sources, there are also non-point sources of pollution that do contribute to, the water quality or the conditions in our receiving waters. And so Matt is going to delve into the Chesapeake Bay example and sort of just illustrate sort of all of those kind of thorny issues. How do you control both point sources and non-point sources? And I think he's also going to touch on TMDLs as well.
Yeah, absolutely. All right, well, thank you, Nizana. We'll grab that. And so let's talk a little bit about the Chesapeake Bay. Why are we going to do that? First of all, that's the work my organization does, and so I'm biased in thinking it's very interesting. But also, like Nizana said, I think it's a really good case study in cutting-edge work to try to clean up a very large and important body of water that's impaired by many sources of pollution, including non-point sources. So you can see the map on the right there. That's the Chesapeake Bay Watershed. It's really big. It's 64,000 square miles. And on this slide, you can see the states that it covers, but the headwaters start up in New York, and it runs through Pennsylvania, Delaware, Maryland, D.C., Virginia, and West Virginia. So that's a major challenge. And so just to set it up a little bit before we start getting into the Chesapeake Bay specific stuff, to just recap a little bit what Nizana talked about. As she described, point sources that discharge pollutants into navigable waters have to get permits. And the key thing there with permits is they have to apply control technology. They generally have to meet discharge limits. They're usually numeric. And if they don't meet those limits, they're going to be subject to enforcement suits, including by citizens who can bring suits under the citizen suit provision. So that makes it relatively easy. It's not perfect, but relatively easy to enforce against point sources. And the Clean Water Act has been pretty successful over the last 40 or so years in cleaning up point source pollution. It's not perfect. It's still a problem, but it's been a great success story. But non-point source pollution has not been a great success story, and that's really the largest source of water pollution that we're dealing with today, and it's not easy. Non-point source pollution comes from many different diffuse sources. It's water running on ground that ends up in waters. So that's farm fields, that's our lawns, that's our public spaces, that's picking up contaminants and ending up in the water. So it's a major challenge. It's a lot of land to worry about. And those non-point sources don't require Clean Water Act permits. So what do you do to clean up a body of water when there's a lot of non-point source pollution? You can't just sue point sources to do a better job. You can't require point sources to eliminate their discharges any further. How do you achieve the Clean Water Act's goals of achieving your water quality standards and meeting your designated uses? Well, you turn to the Total Maximum Daily Load program, and that's what we're doing in the Chesapeake Bay. So again, just some basic facts here. Very large, a lot of shoreline. Both Congress and President Obama have declared Chesapeake Bay to be a national treasure. President Obama had a 2009 executive order that made it a federal priority to clean up the bay. In terms of an economic resource, not setting aside just the environmental benefits, as an economic resource, economists have estimated that the bay's value is something like $1 trillion. So it's a very important economic resource. From an environmental perspective, it's one of the largest and most biologically productive estuaries in the world. We've got 500 million pounds of seafood coming out of the bay every year. It used to be a lot more when the bay was healthier, but talking about crabs, oysters, rockfish, and a lot of that good stuff that people love coming out of the bay. Also just supports a very diverse ecosystem. It's home to more than 3,600 species of plants, fish, and other animals. It's a key resting place for migratory birds. So it's an important water body. And it's impaired. Primary pollutants of concern aren't heavy metals coming out of factories. It's nitrogen, phosphorus, and sediment. And the primary sources of pollution are non-point sources. Point sources are a problem. Wastewater treatment facilities are certainly a major part of it as well. So not to put all the blame on agriculture and urban and suburban runoff, but agriculture in particular is about 50% of the nitrogen and phosphorus that ends up in the bay, and about 65% of the sediment. So tough to clean up the bay without doing something about those non-point sources. And one interesting thing to note, just because I don't know if people always think about this, but atmospheric deposition, what goes up into the air also ends up in the water. And the Chesapeake Bay watershed, the watershed, like I said, is 64,000 square miles. The airshed is something like 350,000 square miles. It's about 5.5 times larger. So coal-fired power plants in Ohio, the stuff that they spit out ends up in the bay as well. So it's a complicated problem. So what do you do about it? What is a total maximum daily load? That's a pollution diet, basically. It's a pretty simple concept. If I want to lose weight, I got to figure out what my goal is and how to cut my calories to get down there. So TMDL is a maximum amount of pollution that a body of water can receive and still meet state water quality standards. So to just run through a little bit quickly what Nizana already touched on, this is that water quality-based process that we talked about a little bit earlier. Rather than starting with the source and saying, what can I do to make that source discharge less, let's look at the body of water and let's figure out how clean we want that body of water to be and work backwards from there to manage our pollutant sources. So you start with designated uses, fishable, swimmable, set your water quality standards, figure out who's not meeting those water quality standards with just the technology on the point sources, and then develop a cleanup plan that allocates pollutant loads and pollutant reduction targets to both point and non-point sources. And so I think that's the key point to really understand in that last bullet, is that under a TMDL, non-point sources end up with a pollution reduction target, just like point sources do. that pollution reduction target isn't enforceable through a permit like it is with a point source, but in theory, it's something that states are supposed to make sure that are attained. And so it's kind of an indirect way at getting at non-point source pollution where you don't have that sort of permit hook. So that's kind of the best we got. So let's look at what's going on here in the Bay. So the Bay TMDL was issued in December of 2010, but it was a culmination of a very long process. The idea that the Bay's been impaired and needs to get cleaned up is not new. There was a Bay agreement that Maryland, DC, Virginia, and EPA first entered into in 1983 saying, let's get this done. And it hasn't happened yet. There's a series of agreements leading up to the Bay TMDL that also didn't get it done. So we're hoping that this time it's going to work. But yeah, it was a cooperative effort. EPA ultimately set the TMDL. It's a combination of 92 smaller TMDLs for all the various water bodies that ultimately flow into the Bay. But the Bay states worked very closely, and DC worked very closely with EPA. This was not something that EPA imposed on the states. This was a group effort. But this is certainly the largest and most complex TMDL ever created, and I like to say it's the most ambitious attempt to clean up a watershed like in the history of the galaxy. It's really cool. Nothing is really unprecedented. So the basic way it works is the states all get allocated a certain amount of pollution of nitrogen, phosphorus, and sediment. Those are the three pollutants that the TMDL covers. Obviously, there are other pollutants that are out there, heavy metals. Those are an issue as well, but in terms of how the Bay TMDL's cleanup is structured, it's around these three pollutants. And so the ultimate goal is to get specific reductions in each one of those pollutant areas. And the idea is let's give an allocation to each state. So, you know, Maryland, you get this much nitrogen, this much phosphorus, and this much sediment. And then you have to come up with a plan called a watershed implementation plan that's going to describe how you're going to allocate those pollutant loads to all the sources of those pollutants in your area or in your state, and end up going county by county or city by city in some cases. So you really get down deep into the weeds at the very local level and have a plan that's going to actually meet those allocations. And EPA requires reasonable assurance that the reductions are going to be met. So what that means is EPA takes a look and says, do we think that you actually have a program in place that is going to make this work? If a state said we're going to get 95% reductions from our agricultural sector, EPA probably wouldn't buy that because that's not likely to happen. So some just key takeaway points here. Oh, sure. I'm happy to answer some questions too. Yep.
Sorry, just a question on that slide.
Yep, absolutely.
How is sediment defined?
How's it defined? I think it's defined as kind of just what you would think of as dirt, you know, just kind of runoff from, that could be coming from construction sites. They're a huge source of sediment. But yeah, it's a good point. I mean, I don't know if it's the constituent parts or it would be, you know, sand versus, you know, topsoil, but I think kind of all of that would fall into sediment. That's a good question. I don't know if you...
I agree. It's all of it.
Okay.
Yeah.
Yeah, go ahead.
Are the watershed implementation plans enforceable? And if not, is that what killed previous deals?
It's an excellent question. I don't think they are. I wish they were. And if you were a really creative lawyer, you might be able to help me come up with a theory for why they are enforceable. But yeah, that's the trick is they set up this framework where we know what we need from point sources and we know what we need from non-point sources, but the enforcement pieces are still tied to the traditional permitting. Like I can sue a point source violator. I don't have an extra cause of action to sue a non-point source or to sue a state for not getting those reductions.
Could another state sue another state? Like Maryland sue Virginia or Delaware?
I think there are mechanisms whereby that might be able to happen. Say Maryland said, because Pennsylvania, the Susquehanna comes down as the largest source of fresh water to the Bay, so that's something like 50% of the pollutants that end up in the Bay are coming from the Susquehanna, and that's largely Pennsylvania. Maryland might be able to. It'd be politically tough. There might be an administration in Maryland that would want to do that, to really point the finger at Pennsylvania. But I don't know how that would play out. It's a very good question, though. It'd be an interesting legal memo to write.
And is that why previous deals have not?
Previous deals, there weren't even these plans specifically in place. They had these kind of non-binding agreements. So similarly not enforceable, very aspirational. Had some specific provisions in them, but certainly nothing that you could go into court and say you have to do And so as political will changes over time too, different administrations, at the state and local level are going to have different interests in really adhering to those. So it's been a challenge.
Also litigation that spurred the development of the TMDL though?
Yeah, that's true. Yeah, absolutely. Yeah, I know that the Chesapeake Bay Foundation and some other environmental groups did sue EPA, and I don't remember what the basis was for that lawsuit.
I don't remember. I think it was that they should have developed a TMDL, I thought, and then...
Yeah, I think that's right, yeah. Yeah, I mean, there was a mechanism in the Clean Water Act, basically, just a little bit of how the process works. States submit TMDLs to EPA for approval, and then EPA can approve or deny. If EPA denies, then it's supposed to set its own TMDL. For a long time, these TMDLs weren't implemented. States weren't writing them because they're time-consuming, they're complicated, and they're politically dicey because you're hitting agriculture and a lot of things that states don't want to have to regulate. And so citizen suits brought litigation I believe in the early 90s, basically saying that if a state has not submitted a TMDL, that's a like after a certain period of time, say 10 years or more of not submitting a TMDL, that's a constructive submission of a TMDL that can't comply with the Clean Water Act because it doesn't say anything. And so that in that case, then EPA has to reject that TMDL and write its own TMDL. So then there was a series of consent decrees that EPA entered into with states where they agreed to write their TMDL so that EPA wouldn't do it. And so it might have been that sort of litigation that prompted it. But yes, that's the history of the TMDL program is quite interesting. So just to wrap up with some takeaways here, the Bay TMDL is legal. There was a big legal fight about that, but it worked out. And the major arguments there, it was challenges brought by the American Farm Bureau Federation, the National Association of Home Builders, and some other trade associations. And what their primary argument was that EPA was exceeding their authority under the Clean Water Act because they were infringing on states' rights to control land use, which is historically something that states are supposed to have control over. The basic argument that the Farm Bureau made that the courts rejected was that a TMDL can only consist of a single number representing the amount of a pollutant that can be discharged into a body of water. In other words, that the Bay TMDL was illegal because the Bay TMDL includes allocations to different types of sources like agriculture and wastewater. They also argue that the Bay TMDL was illegal because it includes target dates for those reductions to be achieved, so that we want to have measures in place by 2025. Their argument was that's too much. Also that EPA was asking for reasonable assurance from the watershed implementation plans that the targets would be achieved. That the Farm Bureau and others said was too much. But the courts disagreed. Middle District of Pennsylvania upheld the TMDL in full. Third Circuit affirmed a 3-0 decision, and just this past February, the Supreme Court denied cert. That did come about 2 weeks after Justice Scalia passed away. So it is kind of an interesting speculation whether if he hadn't passed away, the Supreme Court might have been interested in taking a look at this because it's a big deal, but someone would probably never have an answer to that question. Massive and complex undertaking. All I want to say there is that there's a lot of states involved, a lot of local governments that don't have a lot of money that are being asked to do a lot of landowners, a lot of farmers that are being asked to do a lot, and it's expensive, and there's a lot of coordination that goes into it. But Chesapeake Bay Foundation did do a study, and they concluded that the plan will yield about $130 billion in benefits when fully implemented. So, we could probably argue about some of the assumptions that went into that, but there's at least a good argument to be made for the cost benefit of this. Complexity, I just want to mention, if you want to really have your head spin, look at the model that EPA uses to try to understand what's happening in the Bay, whether this cleanup's being achieved. What they basically try to do is monitor, or try to model the entire Bay watershed in terms of land use, down to the just granular level, and then try to take into account changes in weather patterns over time, try to take into account things like climate change, try to take into account new sources because the world's not static, the world's constantly changing. So you got crazy smart people at EPA trying to figure out how to do this, and they're doing a good job, but it's very challenging. And the cleanup is making progress, but it's primarily coming from wastewater treatment facilities. Like, Blue Plains here in DC spending billions of dollars to improve its wastewater treatment facility, and that's great to have those sources cracking down and really cranking down and doing as much as they can, but that's still bread and butter point source enforcement, and it's not showing the reduction that we need from runoff, from agriculture, and from stormwater. So that'll be the next phase. Yep, go ahead.
For the TMDL, are there any mechanisms for revision, basically like the other counties mentioned? Should, one of the measurements seem no longer relevant, is there a way to amend that? And then the second question I had was, given the TMDL and then the sub-TMDL for all the local places to follow, were there any funding opportunities provided for the federal government, given that everyone's given this big goal to go towards?
Good questions. Yeah, so in theory, the TMDL is based on an adaptive management approach. It's proceeding in phases. Actually, there's a 2017 midpoint assessment, so EPA is in the process right now of figuring out how well everyone is doing and what isn't working as well. And then the watershed implementation plans, there was an initial phase 1 set of plans that the TMDL was based on. Phase 2 plans came out in 2012. That's kind of what's being implemented right now. And the states are going to have to come up with phase 3 plans by 2018 that will take into account what kind of comes out of this 2017 midpoint assessment. And so that's, yeah, that is the process where in theory you're looking at how has the world changed since 2010 or 2012 when we made our initial assumptions, what new sources of development are happening. One of the things that I'm working on right now, to not go into great detail, but there's been a major boom in the natural gas industry. There's a lot of natural gas pipelines that are going in, and not to get into any arguments about fracking or not, but there's a huge environmental footprint that comes with that. And so when you're talking about all the construction that's crossing streams, there's a lot of additional sediment loads, and there's nutrients in those sediments. And right now, the Bay TMDL hasn't taken any of that into account. And so that's one of the things that we're working on right now, is how do we kind of make sure that this does adapt over time. And your second question, reminder. Sure.
I just wanted to mention though, I mean, this approach is not typical.
That's a good point. That's
really
a good point. Yeah,
cutting edge. But unfortunately, I think in a lot of states, I mean, TMDLs often stay in place for a long time without being, changed to reflect.
Yeah, no, that's a really good point. And I will say an open question in the TMDL program that I don't have an answer to. I don't know what the mechanism is for requiring. Once you've done a TMDL once, I talked about that constructive submission theory that got them to do it once. I guess it's constructive submission part 2, but there isn't a clear theory for when you have to update a TMDL. So yeah, that's a really good point. Thanks for jumping in on that. And your second one, sorry.
Potential for funding.
Oh yeah, there is a lot of funding that's being made available. There's USDA programs, EPA provides a lot of funding, a lot of states provide funding. There's a lot of private foundations that are providing funding. So there are opportunities out there. That's one of the main things that you try to do with point source or non-point sources in particular, is to try to provide funding to farmers to use best management practices. So there is a lot of funding that's out there, but it's very expensive, so it's a challenge. And just to end, open question.
Oh, no.
Okay. Yeah, sorry.
Is the TMDL subject to citizen supervision?
To enforce the TMDL itself? No, I don't think so, but I would love to talk if you have any creative theories, because it really seems like it would be great if we could come up with a way to make it enforceable. But no, I mean, that's the big question, is why is this better than the voluntary agreements that happened before? And in theory, there's supposed to be this accountability framework, but it really comes down to, you've got allocations for non-point sources, but if you don't have that permitting level that's being violated that gives you that citizen supervision, you got to come up with other creative theory for how to do it. But maybe that'll be the next great Clean Water Act theory, is that in order to actually achieve what the Clean Water Act's purposes are, these things must be enforceable. So I'd love to do some brainstorming about that. And just last thing, does the Bay TMDL process provide a roadmap for future cleanups? Certainly a lot of states are concerned about that. In the Bay TMDL litigation, there was 20 states not in the Bay Watershed that signed on as amici, saying that the cleanup plan was illegal. And there's a lot of states from the Midwest in particular that are concerned about the Mississippi River Basin, if you've heard about the dead zone in the Gulf of Mexico, the Great Lakes. So EPA, for political reasons or because it maybe just really doesn't know, certainly has not wanted to come out and really make any claims about what might be coming down the road. But it really seems to me that I don't know how you clean up the dead zone in the Gulf of Mexico without something like this. And so I would bet that 15, 20 years, whatever it is, there'll be something similar like this. Certainly there's smaller TMDLs that are happening, but this sort of watershed-wide scale where you're talking about many states, I think there'll be another one. So it's very interesting to me. So I'm happy to answer any more questions. Otherwise, maybe we should keep moving on. Yep.
Has there actually been able to measure some water quality improvement in the Chesapeake Bay as a result of the practices that have been put in so far with point-on-point
Yeah. So my understanding, the Chesapeake Bay program, which is EPA and the states, they did an assessment recently, and they did find, and some scientists at the University of Maryland that study the Bay every year, they did find that things are better. Bay grasses are coming back, and the crab population, I think, is up this year. Water clarity. Okay, yeah. Water clarity is quite a bit better. There are people that are saying, when I've walked out on my dock, this is just anecdotal, but I walked out on my dock, I haven't seen more than a foot down in 10 years, and this year I'm seeing to the bottom. So it's working. So that's a great thing. And right now what we think is that it, again, is mostly coming from the wastewater treatment facilities, and it'll be, can we get reductions elsewhere? But it does seem like it's working right now.
We're gonna shift gears a little bit and just talking about the Section 404 of the Clean Water Act for a little bit. So the Section 404 program, establishes that permits are required for the discharge of dredge or fill material into waters of the U.S. And this program is run by the Army Corps of Engineers, and EPA has a role. EPA develops the guidelines that are applicable here. I can't get into too much detail here. So essentially, there can't be a discharge of dredged or fill material if there is some practical alternative that is less damaging to the environment. So what that means is if there's a proposal to undertake some project that involves dredging or filling of waters of the U.S., if there is some alternative to taking that action that's out there that's less damaging, then that discharge is not supposed to be allowed. And then lastly, a discharge is prohibited if the waters, under that proposal will be significantly degraded. And so these proposed activities are, regulated through the permit review process, that's run essentially by the Army Corps with EPA participation. There are only 2 states that have their own 404 programs, even though all states can run their program. They do have the ability to apply, like they can under the 402 program. So just Michigan and New Jersey have programs. So just quickly, there are 2 different types of 404 permits, and similarly, 402 has these same similar types of permits as well. So there's individual permits, they're general permits. Individual permits are sort of, as the name kind of, as you can tell by the name, it's like focused on, individual projects. It's intended for, discharges that could potentially have significant impacts. General permits, in contrast, are permits are intended to apply to activities that would sort of have minimal impacts on the environment. So like minor road kind of development activities potentially could fall under a general permit. And those general permits can be nationwide in scope, or they can be regional. You can take a look online. I mean, there are lots of different examples out there of these kinds of general permits.
I think we don't answer this, but how many permits are actually denied?
Oh, okay. Don't know. That's a really good question.
It is a good question. Some are, but yeah, I don't know how many.
I have no idea, because part of it too is that, there's the Corps National Office, and then there's also several Corps district offices throughout the country. So, I don't know. Probably someone at the Corps would.
Yeah, I mean, I would say it's probably not a huge number. Just anecdotally, I did used to work at the Department of Justice, and we'd represent the Corps in defending permits, and so, don't speak for the government. I'm just guessing based on my experience, but I think one thing that the Corps did, which I think is a good thing, is they would generally work with the person applying for a permit pretty early on, and so rather than just having a flat denial, it's let's make this permit less environmentally damaging so that we don't have to deny and then litigate over that. So, I mean, I think that, yeah. But there are some. EPA can actually veto permits too, and has done that very controversially in some mountaintop mining cases, and also the Pebble Mine up in Alaska.
Right, but in a limited basis.
Yeah, very, very limited. We don't like to do that. It's tough.
Sure.
Yep.
When general permits are issued, do the activities that they cover, are they generally more or less categorical exclusions on NEPA?
Could you repeat that question again? I'm not sure.
I'm sorry?
Could you repeat that question again? Sorry.
If you're doing a particular activity that's governed by a general permit, trying to establish a crosswalk or the lack of a crosswalk over to categorical exclusions underneath it. And so my question is, if a particular activity, say utility line backfill, you're doing and you can get a general permit, is that list of activities, are most of them, none of them, all of them categorically excluded from NEPA?
Well, it would depend, because NEPA generally applies to, it would apply to federal actions. So
I can answer that. So the Corps does its NEPA analysis actually when it issues those permits.
Yeah.
And so they just proposed a new set of nationwide permits a couple weeks or maybe 6 weeks ago now. But so they'll do that NEPA analysis generally up front.
Right.
And so if you want to make your NEPA arguments, you got to bring them then. And then once that permit goes final, if those permits aren't, struck down in part due to something like a NEPA challenge, then NEPA's, I think, off the table after that, I think.
I would think so.
When they did that most recent promulgation, they didn't revise their categorical exclusion.
I can't answer that. I'm not sure. It's a good question, though. But I think that's the idea behind general permits is kind of that administrative expediency. Let's get these things out. In theory, it's supposed to be I'm building a dock or a small road, very small impacts. But some projects that I do have, I defended some that the Corps allowed general permits for pretty serious impacts. So it's an interesting program.
Okay, so then both under both 402 and 404, those programs regulate discharges into waters of the U.S. And so one of the things we're going to turn to right now is sort of what is the scope of that definition of waters of the U.S. It's defined in 40 CFR 122.2 and includes, these are sort of the clear cases of what is a waters of the U.S. So any sort of territorial seas, interstate lakes, rivers and streams, those are clearly instilled, or I think, waters of the U.S. And we're going to get into some of the more recent developments in terms of the definition and the related litigation just in a few slides. So clearly, what's not included in waters of the U.S. are waste treatment systems, and these are systems that are kind of put in place, to treat waste. So there are many different industries that use them to either as like selling ponds, allowing sort of the various pollutants that are discharged to kind of settle out. And so these ponds generally there are, well, I should say, in some cases there are like effluent limitation guidelines that apply to sort of the operation and maintenance of these things, but they are not waters of the U.S. But the thing to note here is that any discharges from these kind of systems would be considered potentially regulated by the Clean Water Act. So if there's a discharge from a treatment pond into a waters of the U.S., that sort of any pollutants coming from that treatment system would have to meet Clean Water Act requirements, and so they would be subject to, for example, permit requirements and so on. So waters of the U.S. does not generally include groundwater, and so any discharges that are to groundwater would not be regulated sort of as a general matter. They're only potentially regulated if there is a direct hydrologic connection from that groundwater to a surface water. So that's sort of a general state of play. However, under state requirements, states can choose to regulate groundwater, and many states do actually do that. And so discharges discharges to groundwater would be regulated under state law, just not under federal law. So then turning to sort of the thornier issues, and Matt is going to delve into this.
Yeah, so if you've been paying any attention, you might have heard about the Clean Water Rule, and there's a little bit of controversy about that. So I just want to provide a little background. I'll go a little bit deeper than this slide, and then try to move through this fairly quickly. But I do think it's an important issue, and certainly it's very, very relevant in the media right now. So as I think Ms. Anna mentioned, the Clean Water Act applies to, quote, navigable waters. And so the basic question is, what does that mean? We know it's traditional navigable waters like the Chesapeake Bay or the Potomac River, but what else? Does the water have to be navigable? Does it have to be connected to navigable waters? How frequently does it need to have water in it to be a water? And what about wetlands that don't really look like water? They look often more like land. These are all questions that Congress could have answered at some point, never answered in the 1972 Act, and hasn't answered since. And so the agencies, the Corps and EPA, have been struggling with how to define their own jurisdiction under the Clean Water Act, and it's been a challenge. So starting in 1977, again, I'm just going a little deeper than this, but the Corps first took a broad view of jurisdiction and said that in addition to those traditional navigable waters, that non-navigable tributaries and wetlands adjacent to traditional navigable waters are covered by the Clean Water Act. And then since then, that's evolved a bit over time, and certainly the Supreme Court has played a big role in this. They've weighed in 3 times. And the first time was a case in 1985, before we even get to Swank, called U.S. v. Riverside Bayview Homes. And in that case, the court upheld the Corps' authority to regulate wetlands that are adjacent to the United States, the waters of the United States. So we know wetlands are waters of the United States, or at least some wetlands are. The court also in that case said that the term navigable is of limited import in understanding what waters are covered by the United States. So navigable waters, but navigable, limited import. All right. And then we get to Swank in 2001. And the issue in Swank was, in 1986, the Army Corps of Engineers, I guess feeling maybe a little emboldened about broadening things out, passed a rule called the Migratory Treaty Rule, or came out with a rule, I think in a preamble, basically said that isolated waters that aren't connected to traditional navigable waters, that are just within one state, don't cross boundaries, are also covered by the Clean Water Act, so long as they're habitat for birds that cross state boundaries and then migrate. So that's potentially a lot of water. And in a very close vote, actually, 5-4, the court held that the court could not, or the Clean Water Act did not cover those sorts of isolated, non-navigable, fully intrastate waters based solely on their use as habitat by migratory birds. And the court there, in response to the the Riverside Bayview case, said the term navigable may have limited effect, but not no effect at all. So we know navigable means something, but still don't know exactly what. And then we get to Rapanos, and it gets really fun. So there the court decided to weigh in again, and what came out of Rapanos is a rarely seen 4-4-1 opinion, and it generated 2 different tests for demonstrating jurisdiction under the Clean Water Act. Justice Scalia wrote an opinion that was joined by 3 other justices that said that the Clean Water Act covers, quote, relatively permanent waters that connect to a traditional navigable water and wetlands with a continuous surface connection to a traditional navigable water. So relatively permanent waters, don't know what relatively permanent means, and then wetlands with a continuous surface connection to a traditional navigable water. Justice Kennedy wrote his own opinion, went his own direction. He said that waters that either alone or in combination with other similarly situated features in the region have a significant nexus to a traditional navigable water. So there we get this new idea of significant nexus that can be proven through the chemical, physical, or biological connections between the water. But significant nexus, what does that mean? How significant? What sort of proof do we need? Really challenging. Not a lot of clarity there from the Supreme Court. Justice Stevens also wrote an opinion. He said that because 5 justices would have voted to uphold jurisdiction of the wetlands that were at issue in the case under either of those tests, that if you prove jurisdiction under either the Kennedy test or the Scalia test, that the water is jurisdictional. That's the position that the U.S. Department of Justice has taken. Courts have gone different ways with it. I think it's fair to say most courts have agreed that either you can prove it under either test. I think some courts have said you have to prove it under the Justice Kennedy significant nexus standard. I'm not aware of any court that has said you have to prove it under prove jurisdiction under the Scalia standard. But either way, it's the splinter decision has caused problems, and that's why the agencies trying to be proactive, try to fix this, came out with this rule. They've been working on it for a while, and it's fair to say that the rule, as this does, is under litigation. But I'll just talk a little bit about what the rule does, and you can read more about it. But it's kind of premised around the Justice Kennedy standard, significant nexus standard, and it tries to divide up waters into three categories. You've got kind of the always jurisdictional waters, the never jurisdictional waters, and the sometimes on a case-by-case determination jurisdictional waters. So the obvious ones that are always jurisdictional are the ones that Nizana talked about: traditional navigable waters, interstate waters, territorial seas, waters that are wetlands that are adjacent to traditional navigable waters, tributaries of traditional navigable waters. Not a lot changed there. Waters that are never jurisdictional, wastewater treatment systems, certain ditches, groundwater, nothing changed there. The rule maintained all the prior exclusions for agricultural runoff and things like that. But there is this case-by-case universe that's still there. Things, prairie potholes, Carolina and Delmarva bays, moccasins, western vernal pools. I'm not really sure what some of these things are, but they're things that have water in them sometimes, have some connection to other waters in terms of their physical, chemical, or biological impact, and you still have to figure out on a case-by-case basis whether those are covered. So, not surprisingly, this rule was controversial, and lawsuits ensued immediately. There was actually 4 complaints filed the day that this was published in the Federal Register, which has got to be a record. We already covered this. Yeah, I think it was that. So this is just a little chart of what's happened with the litigation, and I think this is pretty up to date. So we've had 22 petitions for review filed in circuit court. Those were all consolidated kind of by random luck of the draw into the 6th Circuit Court of Appeals. The 6th Circuit stayed the rule in October last fall, so the prior state of kind of what came out of Rapanos is still what's in effect. It's not like Clean Water Act jurisdiction is shut down now. It's just we're using the prior regime. The Clean Water Act is not being implemented, so enforcement and regulation is still all happening while this gets sorted out. We've got 18 district court cases filed as well. 7 motions for preliminary injunction. 1 was granted in North Dakota. The U.S. tried to consolidate all those district court cases into one case. That was denied. So why is all this happening? And it's because of this threshold question that they lay at the top. It's not clear where judicial review of this rule should be, and it really comes down to a interpretation of the Clean Water Act's judicial review provision. And there are 7 categories in that judicial review provision of types of actions that are supposed to be in circuit court. And if it's not one of those 7 categories, then your cause of action is to file your claim in district court under the Federal Administrative Procedure Act. And so just looking at kind of the plain language of that, without getting into too much detail here, it's kind of a stretch to think that the rule should be in circuit court. That's the position that the U.S. has taken. There's a lot of reasons from a kind of a expediency perspective, because there's either a 30 or I think it's probably a 60-day judicial review kind of statute of limitations under that provision, whereas under the APA I think it's a 6-year statute of limitations. So if it was proper to challenge this rule in district court, you could wait a long time to do it. So it seems like this is such an important rule, you want it challenged quickly so we could settle it. But the categories that the U.S. has taken a position that the jurisdictional rule could be are an action approving or promulgating any effluent limitation or other limitation, or in issuing or denying any permit. So is the jurisdictional rule, does that look like approving or promulgating any effluent limitation or other limitation? Maybe. Those are smart attorneys at DOJ, and they made the argument, and they won in the 6th Circuit. But it's kind of a grudging opinion. But the 6th Circuit did determine that it has exclusive jurisdiction, so it's proceeding to analyze the merits. I think they had oral argument already, but maybe not. I'm not sure when an opinion is expected there. But what's interesting is that the 11th Circuit, the case that I put on there at the bottom, the 11th Circuit is currently hearing an appeal from a district court in Georgia decision finding that that district court did not have jurisdiction. So the 11th Circuit is reviewing basically the same question that the 6th Circuit just decided on. Did our district court get it right in agreeing with the 6th Circuit, or did they get it wrong? And so there is the possibility that the 11th Circuit will go the other way and say that challenges to the rule should be in district court, and we'll end up with an immediate circuit split. And I don't know if that's something the Supreme Court is going to be interested in, because that's kind of a wonky jurisdictional issue, but that would be an interesting quirk to have a circuit split like that so fast before we even get to the merits. Yeah?
The district court has jurisdiction under APA, what cause of action would that be? Like, would
It would just be that the rule, EPA didn't have a reasonable basis for promulgating the rule consistent with the requirements of the Clean Water Act. And it would still ultimately work its way up to the Supreme Court if that's where it needed to go. But it would just take longer, and you'd have potentially every circuit could have its own challenge. So you could have 11 circuits going different directions. So that's, I think, from kind of a practicality standpoint, I think that's the government's strongest argument, that this should all be funneled into the circuit court. So yeah, interesting stuff there. Some takeaway points. It's complex and politically controversial defining the scope of the Clean Water Act. The agency worked really hard on this. They had 400 stakeholder meetings, and I think responded to over 1 million public comments before issuing this rule. They really engaged both sides of the interests on this, and I think, came up with what they think is scientifically defensible. But obviously there's differences of opinion about that. And congressional oversight ongoing. Congress tried to pass a bill to nullify the Clean Water Rule. President Obama did veto that in January, but there's ongoing committee hearings. The House Committee on Oversight and Government Reform is continuing to very actively ask for documents and want to talk to agency officials about these rules. So a lot of interest from Capitol Hill. I think that the lack of clarity is a challenge for landowners and government agencies and really everybody. It's expensive to regulate when you don't know what the standards are, how to enforce that. It's difficult when you own land and you don't know what your rights are. So I think even if this rule is not perfect, I think it's better than what happened under Rapanos, and I think that clarity is a good thing. And the Supreme Court is likely to weigh in again. I don't know if anybody takes bets on that, or you can bet on whether the Supreme Court is going to grant cert, but this one would be a pretty strong bet. Yeah.
This is kind of more of a technical question, going back to spending the water. So I have it on the survey system, like the water on the system multiprocessor, that when the Army Corps goes out and does it tries to analyze any bodies of water that might not as connected typically, that it's usually like this one person going down and arbitrarily measuring. So how did the Supreme Court in those decisions, or perhaps any district court, kind of not defer to the agency or the court's scientific reasoning? Because I think for Scalia to play scientist is kind of like, where did you draw that authority from?
Yeah, that's a good question. It's very complicated. I think case by case, it's different how the Corps determines whether there's jurisdiction. Certainly once something is being litigated, the Department of Justice will bring in, as necessary, experts to both look at what the initial assessments were and try to beef that up. The other side will bring in its experts and knock down what the government's position is on why it's jurisdictional. So yeah, I think it's a big challenge. I think it is up to the Supreme Court and justices to make sure that the agencies are following the statute, and so he felt like they were going too far. They're really bending that. He was a big textualist, so navigable waters. I'm standing in this wetland. That's a navigable water. There's some intuitive appeal to that. But then you look at from a scientific perspective, what should be covered. And actually, that's just the last point that I'd want to leave you with is I think this situation does illustrate, I think, what's an interesting aspect sometimes of environmental law, and often makes environmental law very challenging, is a lot of environmental law is based on science and connected to science, and science is inherently complex and uncertain. Scientists don't like to be pinned down on things. The world changes over time. But something that we strive for in the law, and there's like the rule of lenity, which is that we want clarity. We want you to know what the rules are so that you know if you're violating or not. And that's like one of the fundamental bedrock principles of good law. And so you've got these kind of diametrically opposed things where you've got, here's the Clean Water Rule. The purpose is to clean up, and the purpose of the Clean Water Act is to clean up water. That's fundamentally science-based. What does it take to get clean water? But so how do you balance setting the court's the Clean Water Act's jurisdiction? How do you balance those scientific considerations that might lead to some uncertainty with that goal of having clarity and having the regulated community really know whether they're violating or not? I think it's really challenging. I don't have a good answer to that.
And I think that's a really great point, and just to even highlight the sort of lack of clarity, especially when you're dealing with the sites. The Corps and EPA don't even agree on the whole, jurisdictional determinations. I mean, there have been instances where there are disagreements between the two agencies about what is and is not jurisdictional. So it is really thorny.
Yeah.
To try to figure that out.
Interesting stuff. So yeah, why don't we're getting towards the end here, so I'll try to move through this fast, but want to just move into one other program that we haven't talked about yet, and that is how the Clean Water Act deals with oil spills and other accidental spills. So Section 311 of the Clean Water Act established the Oil Pollution Prevention Program in 1973. You can read a little bit about what it does up there. The basic the idea behind the statute is it prohibits the discharge of oil or hazardous substances into or upon designated waters of the U.S. and adjoining shorelines in such quantities as are determined to be harmful. And so what does it mean to be harmful? The agencies have said that means if it violates a water quality standard, if it causes a sheen or film or discoloration on the water. The basic point is let's have a system in place to prevent spills and get them cleaned up quickly. That's my major takeaway there. Enforcement of 311 is the dual responsibility of EPA and the Coast Guard, which I thought was interesting. 1990, the Oil Pollution Act. Does anybody know why in 1990 Congress was motivated to pass an Oil Pollution Act? Yeah, exactly. The Exxon Valdez, a lot of pictures of oily birds from Alaska. That's usually why Congress moves on things. So yeah, so that happened here. It amended the Clean Water Act, provided some new requirements to improve contingency planning, make sure that we're prepared, both the government and industry, to prevent and respond to these things. An important thing that it did was jack up the penalties pretty well. So after inflation, currently the penalties available are up to $32,500 per day or $1,100 per barrel, unless the oil spill is the result of gross negligence, which we'll get into in just a second when I talk a little bit about the Deepwater Horizon spill. Then it's $4,300 per barrel. A little bit here on just liability and penalties under the Act. As you can see up there, the Act is a strict liability statute. There's no requirement to prove intent or causation. EPA has got some different authorities that it can use to get penalties to go after violators. It can issue administrative orders. It can also seek civil or criminal penalties. And one of the requirements, Nizana had talked about that states or many states are authorized to implement their own NPDES program, but they have to be able to enforce those requirements and get penalties in order to have that program. Oh, sure.
Quick question or clarifying question.
Yep.
I hope you haven't already. Anyway, who has the authority to set the penalty amount? Does that have to come from Congress, or can, let's say, the EPA set the penalty limit? Well, penalty amount.
Well, Congress sets it. Although I have to admit there is a kind of a mismatch between what's in our regulations and what's in the Clean Water Act. But so the Clean Water Act is what applies. I mean, our regs have not kept up with what's in the Clean Water Act. But,
and there is something like the Inflation Act that applies, I think, to all. I don't know if it applies to all penalty provisions or exactly how that works relative to the U.S. Code, but in general, that will update penalty provisions over time.
Right. But in the case of the way it plays out in states, I mean, basically it's the floor. I mean, states at least have to meet that minimum, but they are free to certainly have, higher penalties.
And in general, I'm sorry, go ahead.
But the state legislature has to okay the higher penalty?
Well, it depends on the state, but yeah, typically most states, that's the way it would work.
Okay.
Yeah.
Yeah, I mean, I guess you could imagine a state delegating authority to an agency to set penalties, but that's probably not something that the state would want to give an agency the authority to do. But you could, yeah.
Right.
Whether it was something that
that's a good question.
Unilaterally could have done to do, or they have to defer to the legislature.
Yeah, that's a good question.
That's why they're so low.
Yeah, no, that's right. And of course, these are maximums. They can go less if they want, and they often do. And judges often go less, but oftentimes the agencies aren't seeking maximum penalties. A little bit just about criminal penalties there. You can read that, but criminal penalties are also an option. And just to talk a little bit about kind of the Clean Water Act and Oil Pollution Act in action and penalties in action, just wanted to wrap up here by mentioning a little bit about the Deepwater Horizon litigation, because that was also a big newsworthy event that most of us are probably aware of. But so just a quick overview of that. What happened April 20th, 2010, the Deepwater Horizon rig exploded, 11 people tragically killed. A couple days later, that rig sunk and oil began leaking from the well. They tried really hard to get it stopped. It took a long time to do that, 87 days. So a lot of oil spilled out. It was the largest marine oil spill ever, with really significant environmental, economic, and social damage to the Gulf region that we're just trying to get fixed up now, and it's going to take a long time. So I'm going to talk a little bit about the civil trial. There was also a criminal case that was brought that led to a settlement. I'm going to focus on the civil piece here. And so this is brought under the Clean Water Act and other civil statutes. But it was such a big case, and BP was a defendant. There was also co-owners, co-operators who were defendants, but we'll just talk about BP here. But there was so many issues involved and so many parties involved that they divided the trial up into phases. So phase one was how culpable was BP. The court found that BP was not just negligent; it was grossly negligent, and it, had some pretty egregious doings or non-doings that helped contribute to this very tragic spill and explosion. And so the major implication of that is that when I talked about the penalty provision, if they were just negligent, they would have been subject to a minimum or maximum penalty of $1,100 per barrel of oil spilled. But because they were grossly negligent, they were subject to a maximum penalty of $4,300. So almost 4 times more costly because they were grossly negligent. Then the phase 2 trial, the question for the court was how big was the spill, how much oil ended up in the water. That was very expert heavy. There's a lot of uncertainty there, a lot of issues around flow rates, trying to look at cameras of how much oil was coming out. The court ultimately split basically between the U.S.'s position and BP's position and said that 3.19 million barrels ended up in the Gulf. And so based on that 3.19 million, times that by 4,300 per barrel, BP going into the third phase was subject to potentially a maximum penalty of $13.7 billion. So potentially pretty high penalty. And then in that phase 3 trial, that was the question for the court, applying those penalty factors, what should BP's penalty be? Don't want to spend too much time on that. You can see what those factors are. There are just a couple ones that I thought were interesting, though. DOJ's approach in arguing it was to say we should start at the $3.7 billion maximum penalty, and then, so this is called the top-down approach. Basically, if there are mitigating factors that warrant going lower, do that, court, but the presumption should be that you start at the top. So that was their position. And a really interesting question around efforts to minimize or mitigate damage and how that should impact the penalty. The government acknowledged that BP did a pretty good job with the cleanup after the spill happened. I think I heard somebody say, they were giving a B+ or an A- or something. So they acted well, but they had a legal obligation to do so because it was their mess. And so the question was, should you get credit for doing what you're legally required to do in terms of the penalty reduction? The U.S. said no. BP wanted to say yes. So I think that was interesting. Also, economic impact of penalty on the violator. That's generally used by the defendant to say, hey, I'm a small operation. These guys are asking for a big penalty. That's going to put me out of business. So we should ratchet the penalty down because of its impact on me. But what's interesting in this case, because BP and BP's parent makes so much money, DOJ was using that to say, we actually need a bigger penalty because these guys print money. And this is not going to have a deterrent effect unless we go bigger than we would need to go for a similarly situated defendant. So also kind of an interesting issue there. And just the last one that I wanted to mention was this: any other matters as justice may require. One of the arguments that BP made that certainly the U.S. didn't agree with, but they said that because they are a major employer in the area and provide a lot of economic benefit, that's something that the court should take into account in setting the penalty so they don't deter investment in the future in the area. So we didn't get a direct answer from the court on applying any of those factors to BP because the U.S. reached a settlement with BP. The court did issue a penalty decision that involved the penalty for one of BP's defendants, Anadarko. So if you want to see how the court thought about those penalty factors, you can check it out there. But we did ultimately get a settlement before that phase 3 went down. decision came out, and there would have been a phase 4 penalty to assess natural resource damages, but we didn't get that far with the trial. But so just here, kind of the quick overview of the terms. This is the largest environmental settlement in the history of the U.S., the largest civil settlement with a single entity ever. I know that Volkswagen settlement just came down. I think those claims are still valid, but that's a big one too. And there's probably bigger ones that are coming with Volkswagen. So this record might not stand long. But included $5.5 billion Clean Water Act penalty. Congress passed a Restore Act, I think, in the wake of the spill, so that more of the money would go to the affected states rather than to the U.S. Treasury. So I think that's generally a good thing. Got $8.1 billion in natural resource damages, and so I think a major takeaway there, though, we've got a lot of money now. Federal and state agencies have a plan in place that they're starting to implement, but they have a lot of restoration work to do. It's good that we've got the money to do it, but generally, you obviously hope to structure this regulatory program so that oil spill doesn't happen, because once the spill happens, no matter how much you get in terms of money, there's a lot of damage and time lost and people that are affected that you can't make up for. I'll kick it back to Nizan to talk about public participation.
Well, I'm just gonna.
EPA loves that.
I'm not gonna comment on that. But generally, just speaking, just high level, since we're running out of time, as we touched on, throughout this presentation, there are ample opportunities for the public to participate, in the implementation of the Clean Water Act. They can, in an administrative context, they can. They're encouraged to comment on, for example, comment on the issuance of permits. And then there is the ability for citizen suits to be filed under 505. They also have the ability in terms of within, following up on the administrative actions. If you have filed a comment, you can seek judicial review. And so I think this is pretty self-explanatory. I don't want to lose time, in case anyone has any other questions.
Yeah, the floor is yours if you have any questions.
Yep.
I apologize if you covered this early on, but under the definition of designated use, is that purely anthropogenic? In other words, covering swimming, things that humans would do, or it also includes the fact that it's a habitat suitable for such and such wildlife species?
That's a great question. It includes all of that. So it includes, both, recreational criteria. Recreational uses. So people swimming or fishing. It does include, aquatic life, and wildlife.
Okay.
Yeah.
Other issues, and we've talked obviously about the Watershed rule that is very controversial, but that Congress, that you guys think that, and maybe you can't comment on this, but you guys think that Congress should amend in the Clean Water Act the provisions that are more or less outdated. I know, especially on the Clean Air Act side, there's a lot of talk about fitting the Clean Air Act to like a carbon as a pollutant, or the aftermath. Is there anything similar on the Clean Water Act talk that it should be revised in some way, shape, or form aside from the water definition?
I think there are. My personal opinion is, but I can't really comment on that. But
Sure. I guess it depends on what Congress you're talking about. I'd say right now I'm happy to not have Congress do anything about it. But if I were to have like my wish for the Clean Water Act, it would be to expand EPA's authority to do something about non-point sources. I think that's an easy fix that would help water quality a lot. So, but I don't think that's ever going to happen realistically. So it's a good question. I don't have an immediate other response. I'll think about that though. Is there anything that occurred to you that?
I'm just familiar at all.
Yeah. Okay. Sure.
I'm curious also about point sources, and I'm wondering there was the two exceptions, one for agricultural runoff and then one for stormwater. But I wonder in situations where, say, a storm breaks a toxic container that then spills, does that become a point source, even though it was technically caused by stormwater? How does that sort of hybrid situation get handled?
Not sure about the specific example that you're talking about, but the definition of point source as we touched on a bit earlier, it's fairly broad. So potentially what you're talking about could sort of become a point source. If you're talking about runoff into a water body, that's where I think things would get a little bit tricky. Could you just elaborate a little bit more about the example?
Perhaps a better example is there was one lawsuit I was involved with where there was actually an agricultural field, and there was a thin layer of frost. It was still the early spring, and it fertilized the field. And then the fertilizer wasn't able to permeate into the soil because of the frost. And then a rainstorm came and washed most of the fertilizer into the water supply. Would that be considered a point source, even though it seems like it's one of the exceptions?
I think that would fall under the exception.
Yeah, I think that would fall under the exception. Yeah, and an interesting case that's going on right now that you could Google if you haven't heard of it, but it involves the Des Moines Waterworks. The city of Des Moines is spending a lot of money to clean up its drinking water that it says is contaminated largely by nitrates from agricultural runoff. And the way that this works on these fields in Iowa, they've got these drainage tiles because there's a lot of groundwater in the fields, and sort of in order to make them usable for growing crops, put these tiles in a long time ago, and these tiles are this sort of discrete conveyance that falls squarely within the definition of point source. But for a long time they sat there and nobody made this argument, but finally Des Moines got fed up and said, we're spending way too much money, we're going to make the argument that those tile drains are point sources. Now the farmers are going to say, or are saying, that, well, that's all agricultural runoff. But what's kind of interesting there, I think that might turn on, is that rainwater or is that groundwater? What's actually in there? And it seems like that should be kind of a silly distinction, but that might be the difference between whether that's stormwater or not. Because if it's groundwater, I don't think it's agricultural stormwater, and then that is maybe a point source if it then is getting discharged from that. It's taking out of the ground, coming up into the point source, and then ending up in a water. So that's an interesting case to watch if you're interested in that issue.
We'll take one more question.
Coming from online, actually.
Sure.
Donna, what can people expect from EPA's next generation enforcement initiative, the Clean Water Act? Are there any specific pieces of the next gen initiative that are going to impact this area?
I'm not sure because I don't work on that program at all, the next gen. I guess the closest thing I can think of is just the e-reporting rule that's come out.
I think that's
important.
Yeah.
And so what that is basically, it was a rule that was promulgated, I think, last year, and what it's basically doing is to sort of modernize our system there. So we are moving to electronic reporting. So of just dischargers are, for example, required to submit discharge monitoring reports. So it's going to make that electronic, and so that's going to make things theoretically easier to track, easier for the public to access and understand. Because right now, a lot of states are dealing with just like paper records. So.
I'll throw in a plug too. ELI just published a citizen science handbook. I think that's something that the states in particular are embracing as they are increasing their ability and data science.
And I will just add to that, I think what's especially interesting from a citizen enforcement perspective about this e-reporting rule is there's actually already a great database out there. It's called ECHO, the Enforcement and Compliance History Online, that EPA puts together, and that covers Clean Water Act permits, Safe Drinking Water Act, Clean Air Act, and RCRA, and you can actually go in there right now. You can do a search based on a variety of different keywords or by zip code, and it'll show you the enforcement history or the compliance history of, like in the Clean Water Act case, the self-reported data. So you can find violators right now that once you went to verify that data, that's a citizen suit right there that you can win. And it's just going to be even better with that e-reporting rule, because right now there's an uncertainty sometimes about if that data is accurate, because like Zana said, a lot of that data that the states are receiving from the dischargers and then submitting to EPA, it's paper-based, and then so somebody, I don't know who does the data entry, but it's a massive data entry to take paper and put it into a database. But in the next couple of years, that's all going to be seamless. The states are going to have to submit it. Right now, New Jersey and some other states just don't submit it, so they're not going to be allowed to do that anymore. And so there's going to be a lot more data that's going to be easy for citizens to use, and I think that will improve the point source enforcement even more, and should be of concern to point sources who have maybe have not been in great compliance.
And it also gets rid of sort of that lag time between, like, because there's usually a phase of, like, checking to make sure, you know, that all that stuff is updated and accurate. And so hopefully it'll be more seamless than that.
Yeah.
We can move on that. With regards to the